Andrew Clapham and Diane Amann, who are here with us from, in the case of Diane, from Athens, Georgia, and Andrew Clapham from Geneva or nearby. He's actually in France, but close to Geneva. We have participants here, Andrew and Diane, from, I'm trying to think of all the countries, but I know we've got people from Indonesia, India, Jordan, Italy, Turkey, India, Mauritius, maybe other places too. So we have quite a cosmopolitan group here. And the idea, what we did, Andrew and Diane, again this morning, we had presentations from some of the students of their ongoing research. And the idea was that this afternoon we would spend an hour or so talking about research and how we do research, some ideas we may have about doctoral research in particular, although I think it's broader than that. And that Andrew and Diane and I have discussed this and said that we would do short presentations a little bit on what we're doing, but very informal. And then we'll open it up for comments and questions, and we'll have a bit of a brainstorming. You have biographies of both of the panelists, and so I'm not going to go over them again. They're very, very distinguished academics in the field of international law and in the field of international human rights. The only thing that it doesn't say, I think, on the CVs is that Andrew and Diane are like two of my most favorite people in the whole world. So I'm really happy. Look at who Diane has with her too. Look at that. I'm really happy that they're here and agreed to do this, and will share with me our love of research and of writing and of academic life. So I think, would one of you, Andrew or Diane, like to start with a few words, a bit about what you're doing and what some of your ideas are on research? Who would like to go first? Diane, you're smiling. Will you go first?
Yeah, I'll go first, sure. So let me introduce my teaching assistant to you. This is Finnegan, and as I'm sure was the case with you, sometime in mid-March, we had to pivot to online education, and he was wonderful in attending classes, peeking in on PowerPoints and things like that in a way that I think helped my students to get a bit of a laugh when they most needed it. So he will get bored at some point and leave, but for the moment he seems quite attentive to the session. I am doing some work right now, actually under Bill's supervision and with his assistance. I'm examining the roles that women played at the Nuremberg trials. It turns out to be a huge project, and a lot of my work initially was figuring out how to narrow it down to something that one could tell in a story that had any meaning whatsoever. Some of you may say, wait, there were women at Nuremberg. That's why there's need for this research, because most people aren't aware of that. And it turns out women did do some significant things, including lawyering. But because they were not generally reflected in the official record in any way that was useful, because women then and now tended to change their surnames multiple times over their life, it was quite difficult to identify who was there, to track them in any meaningful way, and then figure out how to connect them. Because what I didn't want to do was essentially a book with a picture and a brief bio of various women really disconnected. And so a lot of what I've done, and I think this will translate to research for many of you, is the so-called mapping exercise, right? Trying to figure out who's related to whom, who worked on things together, who had ideas about a certain event together, and what could be, if you will, my universe, or maybe a better way to think about it is the picture frame of the story that I was going to tell. And so eventually I have distilled it to the single first trial, which is a nice picture frame because it's 12 months. It's self-contained. It's about one case. And so some of the things that happen in that period that I'm analyzing are constant and already connected. Very different than if I had looked at, there in fact were 13 trials at Nuremberg. And they involved many different individuals, many different issues. To have used that as my picture frame would have made it very scattered. And then I've been able to identify about half a dozen people who did enough and interacted in fact with each other, or perhaps at one degree of separation from each other, to tell a story that has some coherence to it. I would not advise many people to do this as a first research project because it turned out to be very time consuming, but really a lot of fun. And it points to ways to think about research, both historical and otherwise, that I think are important. That keeping in mind that at some point you are going to produce something in writing, and trying to keep in mind at all times a picture of what that is that you're going to produce. So who is the audience? Are you writing for a seminar where you know all your readers are going to be very sophisticated and already well-versed in the material? If you're doing that, that's a certain style of writing, a certain style of research. If you're thinking about something that would be published as a book that aspires to readership beyond the graduate seminar readers, then you're going to be doing your research, you're going to be framing, you're going to be picking out issues and anecdotes that are different, right? You're also going to change your language according to who your audience is. One of the things, as you well know, the United States is not a very happy place right now. And in the conversation that's begun to happen around the protests in the last week, one of the words that has come up a lot is carceral, C-A-R-C-E-R-A-L, which in a certain discourse about prisons and policing is very common, but that's a university discourse. And so there have been jokes made about how can you expect to reach a larger public when you're saying the word carceral instead of imprisonment. And so I think you have to be conscious about, there's a mystique around jargon that may actually distance you from the readers you're trying to affect. The other thing is you need to have a sense of how long your piece is going to be from the beginning. The work that I'm doing now came out of some short essays I did. And if you are thinking I'm writing something that will be 10,000 words, then you're not going to attempt to cover 6 people in an entire trial, because the level of it will be so superficial as to be uninteresting. And so you need to say, okay, I can't do that whole big story, but what can I peel off for this one short piece? And so, for instance, one of the essays I did was on just one woman who was a trial counsel at one of the subsequent trials and had a very interesting life story. And so I was able to do a snapshot essay about her and talk about some of the broader issues without losing the narrative, if you will. I'd be happy to talk about some of the archival methods, some of the theoretical frameworks and legal frameworks that I've been thinking through these problems about, but I think I've said enough for a taster right now, and I'll let Andrew jump in and we can talk more as we go on.
Thank you, Diane. Over to you, Andrew.
Thanks, Bill. Thanks, Diane. I'll try and complement what Diane says and pick up some of the same themes. So the project I'm finishing at the moment is a book on war. And the first point I wanted maybe to make to you is how to think about a title and some of the issues that you'll come up with. Because my book's called War, just that. No, sorry, it's called War, to be clear. And I had some pushback from the anonymous reviewers and the publisher and people that I tried it out with. They said, well, you know, you can't use that. That's an old-fashioned expression and it's not appropriate. And these days you need to talk about armed conflict and so on. And of course, what I was interested in the book is showing how the concept of war is affecting how the law is being implemented, even if it's not technically speaking using the technical concept of war. And so, for example, as you well know, the United States argues in the Supreme Court that because there is a war with Al-Qaeda, they have law of war detainees and that entitles them to detain. And there are law of war targets and war-sustaining targets and so on. So I was interested in the way that the concept affects the law rather than suggesting that it was a legal concept. But as I said, I had to push back and I fought. And I suppose my first sort of tip is when you're designing the title for your thesis, think about what it is that you want to say and not necessarily what other people think your thesis is about, because they might not necessarily get it. And I'm pleased that I stuck to my guns and I managed to convince people. Now for a PhD, the trick that I've sort of realized is that, of course, you want the title also to be picked up by people who are Googling the topic that they're interested in. So you can come up with a very clever and creative title, but if it doesn't relate to what you're trying to talk about, you're going to be passed over. And I always think about a book that was published by Nigel Rodley on humanitarian intervention, and he called it To Loose the Bands of Wickedness, which is a quote from Isaiah in the Bible. It's a great book about humanitarian intervention. I've never seen it quoted. I don't think anybody ever bought it. I'm not sure it's still in print. And I think he realized that, you know, it was a great title for a seminar, but absolutely hopeless as a book title. Now, it seems to me that in the PhD, you've actually got two bites at the cherry. You can have a really long and detailed and explicit title for the PhD, which says what you want people to pick up. And then when it comes to the book, you could probably go for something snappier, so that a researcher will come across your PhD on the internet, know what it's about, and then follow you up and find the book. So that was my first tip. Fight for your title, but be flexible so that you can have subtitles or longer titles so that you attract people to your work. Just like Diane, I also had issues about length, and I think it's a perennial problem for anybody embarking on these projects. I think a PhD should be probably around 100,000 words. I know Bill is keen on shorter ones. That 100,000 word rule came in Cambridge because of the Brazilian judge, Antonio Cansado Trinidad, who wrote his PhD, you know, closer to 1 million words, and pointed out that there was no word count under the Cambridge regulations. So they had to change the rules. But to be frank, you need to keep it short for your audience. Just as Diane said, think about the people who are going to read this. You've got a lot to say. I found that in my war book, there's a lot to say about war, and I found myself writing and writing and writing and calling the publisher and saying, well, I know we agreed a word limit, but I really, you know, I'm going to have to go beyond it. But even as academics beyond the PhD, we have our own constraints on word limit. The reaction they had is, well, you know, you can write all that, but we won't be able to publish it as a reasonably priced paperback. And so again, if you really want the work to get out there and to get read, it's not just about being kind to the readers. I think there are some sort of real commercial considerations to get it into a package which would be read. So it's a very healthy exercise to have to shave off until you get it down to something that is workable. Maybe just a last thought on what to read while writing. When I started my PhD, I was given some very good advice, which was try to find a couple of books that you really appreciate the style of. And just as Diane said, you're writing really a monograph, a book that has a whole argument. It's probably not a whole series of essays or articles strung together. And if you can find a couple of books, maybe slightly different, that sort of speak to you with their style and try to work out what it is in their style that you like, and then keep them near you when you're writing, I've always found that's very helpful, because you can see how somebody develops over a book an argument and the tone that you think works for you. And I suppose my sort of last tip then is try to have books as models, and try to read the whole book all the way through, not just to dip in and work out, you know, the quote that you're going to use, but see how a whole book is constructed, because that's what you're aiming for. And it's a sort of one-off opportunity. Later you'll have to do all kinds of shorter projects. But for this one, I think the art of writing the book is something to deal with. And if you can get your thing down to a manageable size that reads a little like one of the books that you like, or is a melange of different books that you like, that I think then leads to a great PhD. And I'll stop there, Bill.
Thank you. Lots of ideas there. We could spend an hour just talking about the title, but a one-word title, that's very bold, I think, doing that. I wouldn't, when you describe Nigel Rodley's book, his publisher shouldn't have let him do that. I don't know how. Maybe he fought with them. Some writers just insist upon it. You know, one thing that I'd like to see banished, it should be banished for all doctoral students, is putting in the title of your thesis a critical analysis of. I don't know how many theses and master's dissertations I see that are described as a critical analysis. First of all, if it's an analysis, it had better be critical. And if it's a PhD thesis or a master's thesis, it had better be an analysis. So why say it, you know? But anyway, that's just a bit of one of my little obsessions. I've spoken to some of you about my current research project. I know that I've told, I think, certainly Andrew, I've been telling him for 15 years that I'm working on this, but I have always put it off and never, something else has come up and I haven't done it. But I've been finally breaking the back of a project that has been in the back of my mind for many years, which is writing about the customary law of human rights and trying to see if I can figure out exactly what it is. And I always say, when people say, well, what would that be like? I say, well, you know, if you were asked, what does the European Convention on Human Rights have to say about the right to life? You would know where to look for that. You'd go to a commentary, or you'd go on the website of the European Court, you look it up. And if you were asked about another treaty, something in a treaty, you'd go and you'd find the secondary source where that matter has been discussed. But if I said to you, you know, what's the customary law on, well, we heard this morning about the right to education. What does customary international law say on the right to education? Where would you look it up? So there's nowhere, really. We have these isolated references and different judgments to something being a customary norm. The International Court of Justice has done it precisely once in the Belgium-Senegal case 8 years ago, where they said that the prohibition of torture was a customary norm. It's the only time that the International Court of Justice has explicitly identified a customary norm in the area of human rights. So I'm working on that subject, and my research approach to it is that there are two significant developments in the last decade or two that enable us to get a much more accurate idea of what the content of customary law might be. The first is the near universal ratification of the major treaties. The champion of them is the Convention on the Rights of the Child with 196 ratifications. The Convention on the Elimination of Discrimination Against Women is at 189, I think. And the covenants on human rights, the two major covenants, are around 100. One is 173 and the other is 170. And of the 25 or so states that haven't ratified them, about half of them, I think the total population of about half of them adds up to 1 million or something. They're little islands, sprinkled around the Pacific, a few of them the Caribbean. And so we're at a stage where the treaties are achieving near universal ratification. And while a treaty isn't an exact, you can't say, well, because it's been ratified by everyone, it's customary law, there nevertheless is a pretty good argument that it is. There's an overlapping there once you get to a critical mass in the ratification of a treaty. You have to look at others relating to that, reservations to the treaty, and so on. And so I'm doing that. That's one element of it, is looking at where we're at in terms of effectively universal acceptance of these norms. The other thing that I think is a really significant development is what we call the Universal Periodic Review at the Human Rights Council. And that's because it is universal. It's near universal. It's all UN member states participate in it, and they submit reports. And you can go through the reports. In theory, they're supposed to do it. The basis of the review, as the council calls it, is the Charter of the United Nations, which doesn't really say much about the content of human rights, the treaty obligations of states, and the Universal Declaration of Human Rights. So for really the first time, we have all states in the world reporting on their compliance with the Universal Declaration of Human Rights, which is not a treaty, and which is sometimes held up as being a codification of customary law. Well, in practice, when states go to the Human Rights Council, they don't say we're doing this because of this treaty provision or because of this article in the Universal Declaration. They behave as if there's some sort of body of human rights law out there that everybody recognizes and everybody understands, and they make their reports on that basis, and then they get questioned by other states on that basis. So my thesis is that all of this gives a whole lot of material from which you can then say, listen, everybody agrees that, for example, children under the age of 12 shouldn't be allowed to work, or you can't prosecute children in criminal courts at this age, or that everybody has the right to an education, even adults. And so that's what I'm doing in the book. And my goal is not then to write what would be the treaty of customary law. I don't propose to end it with a 2-pager saying, here are all the norms of customary international law. And that's because when you write about a particular human rights issue, who am I? I'm not the guru to go and say, this is customary international law. But what I can say is that there is a great deal of evidence to support the claim that this is customary law, or there's a substantial amount of evidence, or there's some evidence, or that there's not very much evidence, or that there's almost no evidence. And so my idea is to use language really just to convey different levels of certainty about what the content is. And then it'll be for others to use this material and say, well, there's a pretty good case for it, or there isn't. Judges will ultimately customary law comes down to a judge saying that's what it is. So I'm not really aspiring to do that part of it so much as to provide the materials for doing it. So I have just a thought about research that I wanted to share with you. Again, I think I may have mentioned this at a previous seminar, but since our group changes every time, I don't mind repeating it. There was a book I read a year or two ago by an American writer, a writer of biographies named Robert Carroll. He's still writing this famous biography that he's doing on Lyndon Johnson. It's his life's work. And he's about 85 years old, and he recognizes that he may never actually finish it because he's doing it in such detail and so in such a painstaking way. About a year ago, he published a book called Working, where he just discussed his research methods. And there was something in there that I took away that I liked very much, where he said that he had learned, actually he started as a journalist before he became a professional biographer, and one of his bosses, when he was working for a journal and he was doing sort of investigative journalism, said to him, turn every page. In other words, don't get out a file and just sort of thumb through it, but actually look at everything. And I like that. And it's something that is important to me in doing research. Again, I will have said this to some of you. You will know that, of course, well, like all of you, when I start a research project, I tend to rely a lot on the secondary materials, because to the extent that any others have gone ahead of me in doing this research, I want to know what they've said, and it's going to give me some pathways and some shortcuts to getting to the information that I want to get to. But I've also learned over the years that when you look at a secondary source, that you have to look at the footnote and pull it apart and then see if that's actually what the footnote says, the author says it says. By the way, this applies also to primary sources like judgments, and I've done this on many occasions, looked at judgments from international tribunals, and when I'll see something that, I won't do it for every footnote, but when I see something that just sort of tickles me a bit, that bothers me a bit about what they're saying or that I question, I pull out all the judgments and read them to see if they say what the judges said they said. And you'd be surprised how often that they're not quite right. And you pull out the footnote and there are sometimes mistakes in them as well. So this is an important thing, and I recently had an example of this when I'm dealing with a report from the International Law Commission. So the International Law Commission, under its special rapporteur, Michael Wood, who will be well known to Diane and to Andrew, and maybe some of you as well. Michael's a barrister here in London, and he was the rapporteur at the International Law Commission on a major project on the identification of customary norms. And they finished their final report a year or two ago. And so Michael's material is very relevant to my study, very valuable, and it's extremely detailed. I mean, it reads like a PhD thesis. The footnotes are even longer than we would have in a PhD thesis. Meticulous research, but sometimes when you pull apart the footnotes, they're not always quite saying what they're supposed to say. So there's it's a small issue in the question of customary law. But there's a rule that we see in the literature, and occasionally you see it in a judgment, where it's called the persistent objector rule. And the persistent objector rule means that when a customary norm is emerging, but it hasn't yet emerged, if a state opposes that, if a state persistently objects to the emergence of the rule, then when the rule finally becomes crystallized, as we say, as a rule of customary international law, the persistent objector can say, I'm not bound by it. I never went along with that rule, and I'm not bound by it. And there are some examples of that in areas like fishing zones and that sort of thing. But there's almost nothing in the area of human rights on it. So in the report, one of the reports that Michael Wood did, he talked about this rule a little bit, and he explained very accurately, I think, the details of what the rule was. But I'm particularly interested in the rule as it applies to human rights. And so there's a sentence that just says, well, the rule is, I'm trying to remember the word now, frequently addressed by the courts. And they make rulings on the issue of persistent objector, and there's a footnote with 5 decisions, and 3 of them are human rights decisions. One of them is from the European Court of Human Rights, and one of them is from the Inter-American Commission on Human Rights, and one of them is from a US Court of Appeals. But when you go and look at what they say, each one is dealing with the issue of persistent objector. But when you read the judgment, it's not that the respondent in the case is raising an objection because is contesting the application of a customary rule at all. It's merely a kind of a throwaway sentence about norms of jus cogens cannot be subject to persistent objection, that the persistent objection rule doesn't apply to a norm of jus cogens, and this is a norm of use cogents. Yeah, that's fine. It's an interesting statement, but it's not quite what the report of the International Law Commission says it is, which is an example of the courts having this rule submitted to them and them adjudicating on the rule. And so I come to the conclusion somewhat the opposite of what Michael Wood's report says. It's not a big deal, but it's a detail. What it's interesting is that there's almost no objection to the formation of customary norms. The only examples we have that I can really see are these cases of the United States, which has occasionally said they objected to the customary rule that you couldn't execute people for crimes committed when they were under 18. And there's also one example where they said they've objected to the rule that you cannot imprison juvenile offenders, sentence them to life imprisonment without the possibility of any release. Beyond that, you hardly see it. And I think what's interesting is you don't see it either in the materials of the Universal Periodic Review, which would be the place for it. That's where you'd expect the state to come and say, by the way, lots of people are arguing that this rule is emerging, but we want to tell you, we do not believe that everybody should have a right to an education. We're against that. Or that, the state doesn't have to provide people with medical care if they don't have the means to arrange it for themselves. You actually don't see it. And I think that's part of what's so significant. This body of customary law is now huge. And I think this line between our treaties and custom is becoming grayer and grayer. So I'm going to stop there now. I've said probably more than I was supposed to. And maybe Andrew and Diane.
May I add one thing to what you said? This is with regard to the question of primary and secondary sources. Bill just gave us a great illustration of why it's really important to unpack that. I tend to have a different process than I think some of my colleagues do. If I know that there's a primary source that is going to be significant for my research, I read that and work with that and decide what I think about it before I read any secondary literature. Sometimes I've read the secondary literature and that's how I got to it, but I really try to screen that out because I don't want to be influenced for the very reason that Bill talked about. I don't want to be influenced by other people's coloration of what a document says. And so if I knew I were doing the right to education in an article or a thesis, my first exercise would be to gather every relevant treaty, declaration, statement of principles by the UN dealing with that, general comments of treaty bodies. And I would comb through all of those and begin to sketch out what in those is important and what I think about it, and begin to determine what my argument is from there before I look at any secondary literature. I think it's in the end a quicker way to go because it's so easy to get lost in the secondary literature. There's always another article. And it makes you a much more critical reader of the secondary literature to the extent that you're going to include it in your thesis. Part of your job is to try to reanalyze things, right? So you want to have a pretty strong idea about what the right to education is in order that when you go back to what Bill said it was in an article 5 years ago, you can engage with him at a critical and at a level of an intellectual peer rather than saying, oh, well, he must be right. Lots of people do that, but that's not what research and intellectual inquiry is about, and I think it's really important to figure out what your position, at least as a research hypothesis is, before you get bogged down in too much secondary literature, and most importantly, before in those sort of weird subconscious ways, the secondary literature shapes what you're going to think about the issue. So primary sources, the second you see that wow, I'm not going to finish this project without reading the actual decision of the House of Lords in the Pinochet case, right? If that's central to what you're going to talk about, you should drop the law review article that made it clear to you that that's important. Go find that judgment and work through that before you go back into anybody else's commentary about what that judgment said.
Maybe just to build on what Diane said, because it's inspired me to another point about primary sources, which I've come across in the War Book. And that is to go to the original language version of the text that you're dealing with. I'm lucky because I have access to students from all over the world who can help me with the translation. But in my book, just to give a very trite example, one of the things that I bother about is whether you're talking about war with a capital W or a small w. And often a capital W will signify a legal state of war between two states, and war with a small w is a sort of casual way about talking about any old conflict. And of course, when people transcribe, big authors like Vattel or Grotius or whatever, it gets all jumbled up and you lose what they might have actually been trying to say at the beginning. And so by going back to their original writings and getting a good version in the original language, and then asking somebody to help you with the translation, you can often make what might seem to be a rather pedantic point, but you're not at least replicating the error that other people have introduced into the writing. So to give you examples, I've recently been using an Israeli student and a Japanese student to help me with things from the Israeli Supreme Court and from the memoirs of a Japanese prisoner of war, because I realized that the way it was getting mangled in translation, I was missing out on things. And so I can say to them, yeah, but is the word there really war or is it conflict? I mean, how is the Hebrew getting translated? And then you're beginning to say something original. So I totally agree with Diane. I always try myself, as she suggests, to try and go and read the decision before you get influenced by the secondary reading. But because I know a lot of you are working in multiple languages, have a thought about going back to the original language version. It's a bit of hard work. To be frank, with Google Translate, you can usually identify at least the paragraph that you're interested in, and then get somebody expert to help you as to whether it really says what other people say it says, or whether it says something that you can actually start to comment on and say something original. I'll stop there.
The other thing I'll add to that, I have another example that might fit with this. A spin-off piece that I'm doing is another chapter on one of the women that I've identified who had an amazing life before and after Nuremberg, including a turn in colonial Indochina just before and at the beginning of World War II. And that fact, through a bunch of avenues, got me to look again at the Lotus Decision of 1927 by the Permanent Court of International Justice. Perhaps the most famous decision of that particular court. And the official English version of the passage that I'm interested in refers to law holding sway, and it uses the word sway, which in English, that's not a very meaningful term. It turns out that the original French, by the French judge who wrote it, he used the word empire, French, the law's empire. And given that what I'm interested in is a post-colonialist look at that judgment and this woman's experience, the fact that the English translator of the French judge did not say law's empire, even though that was the judge's word, allows for a really fun exploration of how the court, or some on the court, some in that time in 1927, were uncomfortable with the implications of the use of the word empire. And that is something I haven't read anywhere else about that judgment. And so sometimes that primary work, you can come up with things that enrich the discourse on a decision that most people feel everything that could possibly be written has been written about it. by going back and looking with fresh eyes, and perhaps it's your own language or your colleagues' language abilities that get you there. Perhaps it's because you're looking at that opinion with a post-colonialist mindset. And it's going to look very different to you than it did to someone who was looking at it from a different doctrinal perspective. So you have to kind of trust yourself to see things that are new. And sometimes you can do that by going back to those primary sources.
I'm looking for those famous Zoom hands being raised by people. I haven't seen any. Would anyone, any of the participants like to ask a question or make a comment?
Julia, you had your hand up before, I think. No, oh, sorry. Oh, Andreas now does.
You're on mute, Andreas.
That's great. Yeah. Hello to everyone, and especially hello to my former supervisor, Professor Clapham. I hope that you're great. And I can say that I like more your office in the Graduate Institute than the library in your house. Apologize for that. So the major question, as I have been cooperated with both Professor Schabas and Professor Clapham, and I'm interested in this discussion. It's about how you're choosing your primary sources. In my career as an academic, as a starting academic, I have read a lot of your books, both of you, and Professor Amann, I apologize, I'm not that aware of your work, but I promise I will be the next thing that I will do. I have seen that you have dealt with difficult topics, especially in particular, the Professor Clapham's PhD thesis was a topic that was never exist before. So how you are doing this choice of the first materials, on what are the criteria and how you are sure about that. And the second question that I have, it's something that I have discussed a lot with Professor Clapham. It's about the style, on how you approach your audience and what you want to say to your audience, and to be clear and simple as possible, while on the same matter you have an advanced vocabulary and an upgraded way of putting the things on. So this is the two things that I would like to ask. To say that I'm waiting for more than 2 years this book for war, so just speed up the situation if it's possible. Thank you.
Thanks, Andreas. Andrew, do you want to react? You're on.
He might have stepped out for a minute.
Yeah, he might have. Yeah, he's just giving me his picture here. Okay, Diane, any reaction? We have another. Maybe we can hear from. Is it Zan?
Hello. Yes.
Go ahead.
One thing that I really find it fascinating is the about the back into the original context when you're doing some work, and also the translation that sometimes is missing. But sometimes I find it like it's very hard for those countries that influenced by I can say like they've been colonized, like Tunisia, which I'm doing, has two kind of contexts, which is French and Arabic. And sometimes back into the Arabic context, you find one kind of perspective, and when you back to the French one, you find another one. It's more like two different words, which one explain that it's another one cannot understand. If you back to Arabic, for example, you can refer to the Edward Said understanding, that's saying that understanding Middle East and North Africa by Western orientation is totally wrong, and is not being addressed Middle East and North Africa properly. And when you're back to the French one, the conception that they're trying to explain sometimes is not transferred totally. What your recommendation is for this kind of battle for the student that they don't really know what kind of perspective they should bring to their own research.
What is the specific topic that you're working on?
I'm working on implementation of human rights under the influence of civil societies and universal periodic review. What I find it is more difficult on civil societies, because in civil societies conception, in Arabic, it's totally different. Even the word is different, and they claim that it has been existed within the constitution of the Arab world since the Islamic empire's been established. So what I find it hard is some of the organizations that work in Tunisia, they're trying to kind of showing to the society that this is kind of how to say مجتمعات المدنية, which is like civil societies equivalent, but they're trying to make it more localized, more adopted by the culture, which sometimes has become paradoxical in terms of human rights. Let's say.
So I think you have some choices to make, right? If those discrepancies are important to the story, you're in a unique place to explain them, because you have familiarity with both cultures and both languages, and you will have to make that part of your problématique, right? And
Yes,
you're going to have to explain that we can't, when we're working in these two different, in a state, Tunisia, that is effectively bijuridical, because it has these overlays of two traditions, that everything you're talking about has to be analyzed through both frames, right? That we can't take at face value the meaning of any particular word. And it seems to me that to go through that exercise would be very valuable, because you're in a unique position to explain it. It perhaps feels more obvious given the nature of Tunisia, but in some of the work I've done in the past, I can assure you that the term rule of law in English means something entirely different than its equivalent term in French. And so I have been in roundtables with French scholars and jurists and Americans, and we both throw out in our own language the term for rule of law. And inevitably, at the end of the day, we discover we've not been talking about the same thing at all. Because the philosophical understanding of the role of the state in a continental system versus a common law system is almost opposite. And so the problem exists even in areas that we think of being as more homogeneous, but that's what makes research interesting, and that's the scholarly contribution you can make to explore those discrepancies and explain them for those who are unable to engage in the material the same way you are. I'm going to pull out for a minute because I just discovered my computer's not plugged in.
I can just add to this discussion about languages. I think Andrew Clapham's point about using, as he says, he has this great resource of all these students from all over the world who can help him. But he said as an initial resource, you should look to, you can use Google Translate. And I use Google Translate a huge amount. I think it's extremely useful. And I think often, actually, you don't need to go beyond Google Translate. I'll give you, again, an example. In the research I'm doing, it involves, amongst other things, canvassing the case law of the various international courts and treaty bodies. So the Inter-American Court of Human Rights, which is an important institution, issues most of its decisions now in Spanish, and they're not translated. You know, although there are 4 languages in the Western Hemisphere, Spanish being the majority, the main one, but also English and Portuguese and some French, but they only issue them in Spanish now. And so people say it makes their case law inaccessible. I think that's maybe overstating it, because even if you're not, and I'm not at all fluent in Spanish, I've never studied it. I get some of it because I know Romance languages. I studied Latin at school and I can speak French. So I can stumble my way through the Spanish and it makes a little bit of sense to me. But Google Translate gets me right to the point. And I find that I can do a lot of my research just using that. And if you get to a point where there's some very difficult issue of trying to pull apart a sentence or two, and you're not quite sure what it means, or you're dealing with the real semantics of it, as Andrew is, when he's talking about war and conflict and trying to get the word right, yeah, maybe at some point you have to go and get a specialist. But a lot of the work can be done using Google Translate. And I think it's important because, you know, when I started, when I was at university back in the 70s, we had a rule that to get a master's degree, you had to do an exam in a second language, okay? And it had to be a language, had to be a language that was relevant to this, what you were studying in your research. So if you were doing modern literature, you had to do, or European literature, you had to do English, and you had to show you could actually read in French or in German or in Italian or in Spanish. And when you got to the doctoral level, they were talking about 2 languages. They expected you to have some fluency. And so this was way before Google Translate existed. We've dropped all of that now. We don't even talk about it when we have research students. It's unthinkable. And yet, to do your research properly, the idea that you just do it in one language is so narrow and finally unacceptable if there's relevant material in another language. So I know there are limits to what you can do, but certainly if you're dealing with some body of law where there's material in, relevant material in 2 or 3 languages, it's international law. You know, we're not talking about, not every language in the world produces relevant material in public international law, but more than one does. And so it's worth, you shouldn't neglect that.
Thanks
Andrew,
so much.
are you?
Yeah, sorry, my computer crashed. Too much video, I think, but I put it on my iPhone now, so I'm back with you.
Welcome back. Any other comments or questions from the participants? Itaf, yes, in Amann. Please join us.
Yeah, well, thank you very much. This is indeed a very interesting.
Sorry.
We don't like to hear people coughing these days, Itaf.
I know it's quite worrying, but I mean, no, it's allergy basically. So it's indeed very interesting discussion. And as a researcher, we always face the issue between, I mean, looking into the primary resources and secondary resources and trying to find a way through these 2 different resources and to articulate something really meaningful during the journey of the writing and the thesis. I remember first when I joined the PhD, I had a discussion with Professor Schabas, and somebody, I mean, because I'm engaged too much like in INGO's work, in which actually advocacy is a good part of what we do, specifically when it comes like to support the most vulnerable population in development of humanitarian setting, like for children, we tend somehow actually to speak too much advocacy and advocating for changes and to make things change quite rapidly. And I remember from my first conversation with Professor Schabas that he told that I shouldn't mix up between advocacy and between research, and that legal research is something actually quite scientific with specific methods, so it's not really an advocacy. But again, I just want actually to speak the point that Diana has mentioned, Professor Diana has mentioned about having a stand in your research and using different resources actually to strengthen your stand. I mean, speaking about stand, is it something actually that personally you believe in, and you would find an evidence from different resources like primary and secondary resources that you can advocate? I mean, eventually it's going to be a kind of an advocating for something and for changes. Or is it purely scientific, and how far that we can make a distinction between being a researcher in terms of being neutral and independent, and the same way having a stand in your research. And somehow I find it difficult, because while you going through writing journey, there is some kind of an emotional attachment toward a case or a position or a defense toward something. So I'm just actually curious to hear about your perspective about having a stand and position and advocating, and sometimes being a very much of a rigid researcher.
Well, let me rephrase what you call stand. Maybe from a scientific perspective, we should think of it as our research hypothesis. And of course, we're all going to engage in research that is interesting to us, right? So there are questions we're interested in, and often that means we have some preconception of how we should think about the outcome. I mean, that's just human nature. But if you think of it from a scientific and an intellectual perspective as a hypothesis, and then leave yourself open to be shaped and reshaped by your research, I think that you are achieving the goals that Bill was talking about. And I'll give you an example. I taught a refugee and asylum law seminar this past semester that ended in research papers by my students. And one of my students wanted to study the use of biometric data by the UN High Commissioner for Refugees to identify and track refugees. And she began with a sense of utter outrage about the invasion of privacy of the individuals, and her reason for wanting to investigate this was essentially to condemn it. And I was so delighted that in the process of the 14-week semester, she decided that maybe it was a necessary evil, that it was more protective for these individuals to be identified, to be tracked, that it gave them a sense of identity and community that were marginalizing them. And that although the evils are obvious, that abolishing this way of giving them an identity in communities that generally try to make them invisible was not the solution. And so the paper she ended up with was much more nuanced. It relied on actual research. She read the UNHCR's guidelines on it. She read empirical studies. She read tech articles about the risks. And she certainly didn't end up certifying it as the best thing ever. But she came to a result that was much more sophisticated. And that was because she was open to being persuaded through her research that her original hypothesis was not perfect, if you will. And so I think if you have that kind of commitment, of course you're going to care a lot about the issue, and you may have some ideas of what you think is right. But as research scientists, we need to be open to discover, well, I need to reshape my thoughts. This is a much more complicated issue, and my commitment is to identify the pluses and minuses and make sure that the benefits at the end of the day outweigh the minuses. So I think that's how I would respond to your query.
Andrew, any thoughts?
Yeah, let me try and add to that. I think sometimes there's a temptation when you're trying to make an argument, whether you call it activism or argumentation, to sort of overlook what's been written, which goes in the other direction. And I think in a good PhD, one can make your argument and be activist, if you like, in pushing it forward, as long as you show that other people have had the opposite idea and why your idea is more convincing than their idea. So in writing the book on war, I've often been tempted to sort of ignore a whole slew of authors that I basically disagree with and who have quite good arguments as to why I'm wrong on lots of things. But I've thought it's only fair to the reader to sort of put those people in the footnote and just use, contra, or this person disagrees, but I disagree with them. And I think that way you're sort of building your argument and convincing your audience. You might at the end of the day be wrong, but at least you're not cheating the audience into them thinking, oh yes, of course, that's the only way to think about it. Now, of course, if I was, I don't know, representing Amnesty International in a meeting, I wouldn't feel obliged to show all the authority going in another direction and all the good arguments the other way. It's a different forum. But in a PhD, you're doing something scientific and you're expected to know all the arguments that have been made by other authors. And if you're tempted to skip over the others, catch yourself would be my advice. Put them in and show why you think they're wrong. I'll stop there.
I can add maybe to this discussion on this point, this project I'm doing on customary international law is literally infected with the problem of trying to write about customary international law and distinguish between what you would like it to be and what it actually, in the sober analysis of the facts, actually is. And it's not just a problem of the researcher. All of the secondary literature and the judgments are riddled with that as well. People making pronouncements about, they'll say, well, I think this is customary in international law. Why? Because they'd like it to be customary in international law. So I have to confront that problem in the research project I'm doing all the time. And I'm not sure that I'm entirely immune from it, that I'm going to be able to avoid it altogether. But I'm also conscious of the fact that the credibility of the exercise depends on being able to show that I can do that. You know, one of the subjects I've worked on all my career is the abolition of capital punishment. I would dearly love to be able to say that the abolition of the death penalty is now a norm of customary international law, but it isn't. I can't do it, and and so I have to sort those things out. And maybe one of the ways I'll get around it is to say, I really would like this to be a norm of customary international law, and we're getting there, but we're not quite there yet. So I see I've got hands up from Ezekiel first, and then Francesca, I think in that order. So I'm going to turn to Ezekiel, and Damian would like a word as well. So Ezekiel.
But Damian as well has had his hand up.
Okay, well, so is Damian first? Yeah, maybe. Damian, Ezekiel, and Francesca.
As you wish. Well, thank you. Thank you. This is also interesting. Just two comments I'd like to make. First of all, I just have a book on my desk, going back to the comments on whether we should be reading or you should be reading regional sources. I think this is really, really, really important. So I'm just finishing an article that also deals with Friedrich Nietzsche. So basically the book is on the genealogy of morals. I hugely, hugely recommend it. And when I was writing the article, I actually was consulting, secondary sources. So basically reading articles and books on this book. But then in the end, I said, if I'm a serious scholar, obviously I need to read the book itself. And it's really, it's a completely different story if you're reading the source that you are writing about. So this is really important. And again, I hugely recommend this book. But of course, it also—
You're reading it in German, Damian?
No, this is actually in English. It's on the genealogy of morals, Friedrich Nietzsche's. I was reading it in English because I bought it in Cambridge some time ago. And a spectacular book. But of course, it also depends on, where you are in terms of your intellectual development or how difficult the primary source is. Because, if you attempt to read Hegel's work, Hegel is notoriously difficult to read. So, then you would probably always have to consult some secondary sources. So probably a combination of both is a good way to go for PhD candidates. And then just another point that was raised, I think by Itaf, sort of should you be neutral in your research? I totally don't think you should be neutral in your research. I mean, I would like to hear what others have to say about that. But I mean, obviously you have to start from a position because you're adding your own personal reading, to the topic you're dealing with, and you have to bring your own, life experience to the story, and even prejudices, and so on and so forth. But then, as was mentioned earlier, it's really important that you're open to opposing views, and so that you're really openly dealing with people who disagree with you. So I think, when you're writing a PhD, I think a good balance. Or not a balance, but takes into account both of these perspectives. So first, writing from your own standpoint, and second, being honest and rigorous about what's out there is really important. So yeah, just a comment. Thank you.
Thank you. Can I turn to Ezekiel now?
Yes, thank you very much. Pleasure, obviously, to be with all of you in this very interesting Zoom meeting. I have a question for our panel today regarding the politics of sources. And I'm talking about primary sources that deal with statements from government officials. Just to give you a quick overview, I am doing a PhD with Professor Schabas on the Assembly of State Parties to the International Criminal Court. And a lot of the work surrounding what they do in the Assembly and some of the decisions that they actually take that affect the operations of the court are highly political. And I'm sure there is ample evidence over the last few weeks on that, especially in the US. But a lot of those comments, when you read them and in the transcripts of those meetings, if you wanted to make some observations about what is the behavior of these states in relation to the court, you have to understand very much what are the politics at the national level. And depending what argument you want to make, you can pick and choose which states you want to quote. If you're looking for the more progressive angle of the argument, I'm going to look for the like-minded states. If I'm looking for something more in middle ground, maybe the Europeans. And so there is a bit of competition there in the argument itself, how we construct, a narrative around how we use these sources to make an observation that is, supposedly to be general as a contribution to the scholarship. So that's a bit of the conundrum I face sometimes. Try to be obviously impartial and follow a methodology that you can weed out some of the outliers. But I just want to hear your experience in doing some of that work as well. Thank you.
Anyone wish to react? Diane? Diane, you have your microphone off.
My dog was snoring, which is why I put it on mute. I'd like to respond to that by recommending that you have a look at some of the US literature on the use of legislative history, and particularly the critiques of that use. What the concern that you're talking about, we often refer to here as cherry picking. Right? Finding the ripest fruit, the nicest fruit from, we all know if you've ever looked at the readout of a Security Council meeting or things like that, everybody comments, right? And lazy scholars will jump to the juicy cherries that support their position. And the same thing with, Andrew referred to Amnesty International and other bodies that are forthrightly advocates. And they will do it in a way that suggests there's no other commentary out there. And so I think you'll find some reading if you look in that space about that problem and how you might account for it and try to minimize it. The other, and so if I were reporting on, say, a debate, I would think as a researcher, you want to be forthright in your description of saying, there are inevitably problems with this kind of exposition because there's the risk of emphasizing some things and not others, right? That I'm going to do my best to show the debate in whole, but this is really risky business to try to do that. The other thing that I think that gets missed that's a really important point in those debates is most of the potential speakers say nothing. And that, silence can speak volumes. And so you need to think about what it means is if it's only the US and Israel that are saying anything on the issue and everyone else is remaining silent. Are we supposed to take that as acquiescence? Are we supposed to take it as the now famous Justin Trudeau 21 seconds of silence because it's not safe to say anything publicly about what you really feel? I think that in some ways in debates about states, and Bill was talking about the formation of customary international law, it's the silences that are underexplored more than the statements that are made, because we have these bodies with 200 members and 30 of them make statements, and because they spoke, what they say becomes characterized as the debate. But the fact that everyone else remains silent is at least as important.
Andrew.
Yeah, just again, riffing off what Diana said, I think it's quite important to see not, how many states said this or did they agree with you, but what kind of states they are. So, I mean, in Bill's project, I guess he's had to look at states that are most affected in some contexts. So I'm thinking of the work on Indigenous people's rights. What Canada and the US and Australia say is somehow more important than what other states say. And so or in fisheries, you have to work out what Iceland and Norway is saying and not what Switzerland and Austria are saying. So, it's not only about finding who said it, but what kind of person said it. So just, again, going back to try and give you an insight from my own thinking, in my project, sometimes there's a stream of authors who think something that I've had to refer to, but they're all of an ilk. And by that, I mean, they've all got very close connections to the military. They're either military lawyers or employed by the military to argue cases for them. Mm-hmm. And so, I've had to sometimes say, well, the following 5 authors have said this, but, they should to be classed as military experts. They're coming from a point of view. And just because there are a lot of them, it doesn't mean that they're right. And one way which I've sort of developed to try to indicate this is that when I'm dealing with a military lawyer, I tend to put their rank after their name, just so that we know we're dealing with a military international law expert, as opposed to a professor or somebody who's working for an NGO or whatever it is. But I think it is a problem trying to sift out the people who agree with you and who disagree with you and how you weigh it. But certainly working on the concept of the law of war, it does rather depend not just what country they've come from, but their actual background. Thank you.
Maybe we'll turn to Francesca now.
Thank you so much, and thank you for this afternoon session. So my question is directly referred to Professor Diane, but also to everybody else, because she was talking about the rule of law and the different meaning in the common law system and civil law system. So I have the same issue. I'm dealing with the term of gender, because in some languages it doesn't exist an exact translation. And of course, the meaning of gender is different. Also, there is a misunderstanding between sex, gender, and sexual orientation. So sometimes when I'm reading the National Constitution or also the National Penal Code, it's very hard because explicitly there is no mention of gender. But of course, because of the case law or because something else, I don't know, for example, because the Constitution and the Penal Code were very old and the term gender is more or less pretty new, they didn't insert it. So my issue and my problem is that sometimes it's hard to compare the different Constitution and Penal Code and try to create a general analysis of not only gender, the term per se, but also gender crimes, and understand if we really need an explicit crime, for example, or we cannot have a specific reference to gender crime in a national constitution, but we can also use the international law and, for example, the Rome Statute and the Article 7.1H. And the combination with the Article 7.3. So basically, this is my problem.
Francesca, do you have what do you say for LGBT in Italian?
Yeah, exactly. Also, LGBT, it's another issue because the acronym sometimes they use LGBTIQ, LGBTIQ+. So there are many acronyms. And sometimes they use the plus to insert everything is different than men and women. So,
but I think one of the things that's happening is that in different languages they're just using the English acronym.
Yeah.
I mean, Diane talks about carceral and detention or prisoner, And you know that you can look that up in a dictionary. It's still part of your language, but how do people understand in other languages when they're using these complicated acronyms that are just taken from the English language?
So I have a couple of responses, and I think you're absolutely right that those are all problems, and particularly with this issue, it's a problem because the terminology is constantly changing. I mean, I have settled on LGBT plus because there are so many other initials depending on people's perspectives that get added to it. There are even those who think the G should be before the L. And so it's problematic because in the American English language that it emerged out of, we have not yet settled on a term either. Here's how I would respond to your problem, and it may go back to the problem about Tunisia as well. When you have a core issue of interpretation, of defining a term of art, of trying to really pinpoint what it is you're concerned about, that may require the rest of your research to be smaller. And what I mean is that even if I were simply doing an article about gender in the United States domestic law, I'm not sure I could do that in 10,000 words. Because in fact, when I write about this now, I tend to say sex/gender/sexuality in order to try to encompass what some people use the word gender for. As you may know, the reason gender arose in the law is that Ruth Bader Ginsburg, when she was arguing sex discrimination cases in, I think, the 70s and 80s, would go before panels of male judges and refer to sex discrimination. Sex was the term in the US statutes, and the judges would start giggling because the word sex had been said in the courtroom. And she found that it was so hard to get them to take her seriously that when she simply switched to the word gender, nobody knew what that meant and they were much more comfortable with it. So the obscurity of the term was what she was using by way of advantage. And that's part of the reason why we don't have good definitions here. But if just figuring out what you're talking about is going to be, let's say, a chapter of your dissertation, then you'd better limit how many types of law or how many countries you're going to be doing case studies of, because that definitional problem will continue throughout, right? And you may find, just as in the Tunisia case, there are times where the answer is it can't be compared, right? Lots of non-English languages still use a version of the word homosexual in places where it would be seen as offensive in American English to use that term at this point in time, given the way that we use terminology. And yet I'm sure many statutes are using a version of that term. And so you simply don't have the space in your word count to take on too many cultures with all of those problems. And so that's one of the framing decisions that I talked about at the beginning that you have to deal with. And even the Rome Statute, it's the last thing that I would use as a framework, because the definition of gender in the Rome Statute is utterly meaningless and tautological and was designed to be, right? It was a response to a certain criticism by the Vatican and others, but the language they came up with doesn't define gender in any way that is useful and actually doesn't achieve the goal of the people in the Vatican that were complaining about it. So it's not the standard that I would use to try to pinpoint. So if you have that kind of problem, kind of like the problem with what do we mean by the rule of law, and that's central to your discussion, the case studies that you're going to use are going to be smaller because you've got so much work to do just in that analytical or theoretical space.
I'm aware that we're nearing the end of our time that we've allotted. I know that Khan has his hand up, and so I'm thinking, Khan, maybe you can have the last intervention,
really
not
quick,
too long,
quick
and then we'll And then we'll go to Alice, and then maybe have Andrew and Diane make a final comment, and we'll call it an afternoon or a morning in the case of Diane. And who else? Oscar, and who else is in the Western Hemisphere? Okay, Khan, over to you.
All right, thank you very much. I'll try to keep it as brief as possible. I had two questions in mind. First and foremost, as regards the question of being an independent scholar, there are certain areas, especially with regards to international law, and also, my doctoral research is basically a work of public comparative law, criminal law, and international human rights law, all matched together in a way. It's on the criminal defamation of heads of state, and basically international human rights law, and basically the state practice among European states. They dictate one thing, and the focal point of my research, basically, at least the high tier courts, they say a completely different thing, and this is basically primary sources. Whereas our I'm focusing on Turkey, and whereas our doctrine is also in line with international human rights law and state practices as far as Europe is concerned. So again, my view is also in line with the majority view. So I don't know where to strike the balance. Sometimes I think that I question myself. I'm asking, well, am I biased? Because I started doing this research, frankly, with a sort of passion, with a passionate advocacy of a certain view, and then I don't know. I don't want that to affect the final product. So I don't know if you would have any suggestions as regards that, because there are areas in law in which there's a clear majority on one hand, and the minority view is just they repeat the same things over and over again. So in those cases, I don't know how you handle it, how you strike the balance between the two, and that's one thing. And secondly, as regards primary sources, there is, for instance, I went all the way back into the 19th century doing research on. Actually, I even went back to the Roman times, etc. But they're more or less well kept compared to the Ottoman sources. And one of the issues that I've come across was that they were incomplete. Some of them were partially destroyed and whatnot. I don't know what to do. I wanted to assess what the jurists of the time thought about certain things in the case law, etc. But the fact that they were destroyed due to political issues, it's just I don't know if you've come across anything of that sort. I know Professor Schabas had with the book on the Kaiser and his trial. More or less, the sources were in Dutch as far as he told us. In the book, it reads, of course, quite, it's almost like a river, and so there are no gaps in between. But I don't know how you've been able to, as you're writing your academic works, how you've been able to fill in the gaps where there clearly were gaps, beyond your control. So I have those two questions. I'm sorry if I couldn't keep them brief as possible, but yeah.
Alice?
Yeah, thank you. Just one very quick question to finish with, if I may, which is, I wonder if all three of you could reflect on the imperative that all writers of PhD theses have to make an original contribution to knowledge, as we call it here at least, and I suppose the different ways in which originality can happen, especially perhaps for those who are not doing field work as such, where there's a kind of inbuilt originality, but for those doing work which is more doctrinal. You've obviously talked about archival research and of course the uncovering of knowledge that can happen that way. But I wonder if you just reflect as broadly as you wish about the different ways in which originality can be assured.
That's a good question. Who would, Diane? Or
right. So in some ways, my response would be a little bit related. I think with regard to contingencies, I would suggest that you look at some writing on the scientific method. At some point as an undergraduate, I read a small version of Karl Popper's version or theory of the scientific method in, I don't know, a biology course or something like that. And it gives us a sense of what it means to create a hypothesis. And it also tells us that the scientific method is based on falsifiability. It's not based on any claim to have come to the final answer on any question. And the reason I think that's somewhat responsive to your question, Khan, is that anything we write is contingent. And certainly if we're looking at any archival materials, there are always going to be gaps. There's always going to be new information. And so I think it's important for the researcher to be aware of that. And again, in their introductory chapter or in the chapter that's really beginning to work through the archival materials, to just straight up say, there are contingencies in the materials I'm using. Famously in Dublin, there was a fire and the vital records of half of modern Irish history were just simply burned. And so there are questions about a certain period of Irish history that we literally have to reconstruct out of the ashes or acknowledge we'll never have clear answers because the records were destroyed. So essentially you're weaving things together and you need to remind your reader that you're doing that. So in the work I'm doing right now, I'm working with letters that were written by my French woman prosecutor and her family during World War II. Some of the letters survived miraculously till 2020, but a lot of them didn't. And so you often have someone writing to a brother and then you never get the response, but then you get the next letter responding to the brother's letter. And you just have to try to imagine what the brother's question might have been that they're responding to. The other overlay is they knew, because they were living in different countries, that everything they wrote and put in a mailbox was subject to censorship by the occupying force. And so everything they write is in code. And we can only guess that we're deciphering their code properly. We might have certain references wrong because they were trying to avoid being caught, right? And that means that at some point when I repeat those conversations, I'm going to have to say that. So my reader understands 5 years from now, another family member might come up with the key that unlocks the code and proves everything I thought I got out of it was wrong, right? And so I wouldn't say don't use those materials, but you have to be forthright about the limitations of those materials. It's not unlike trying to analyze a judicial decision and figure out what the judges, individual judges might have thought when you don't have the judge's own diary at hand, right? You're going to be wrong on some stuff and you just need to acknowledge that. As to the small minority versus the prevailing group, this is an originalism question or an original contribution question. Why is it that it's important to study this now if your conclusion is going to end up siding with the prevailing majority? The answer may be because the minority is gaining power or is getting traction or has attractive arguments, and this is a moment in time where you feel it's important to revisit this issue, to put fresh eyes on it and reaffirm that the majority opinion is right. And I think, looking at where we are in 2020 in countries that have been overtaken by toxic nationalism, there could have been more work done 10 years ago in that space, where certain ideas were coming up that the prevailing or the conventional academic thought were just ridiculous and didn't engage with, and then suddenly they're coming out of the White House or 10 Downing Street. And maybe that kind of critique, that re-examination, that reaffirmation can have value in itself. It's original because you're doing it now, you're doing it with a fresh set of eyes, you're going back to those primary materials, you're adding theoretical frameworks that are important to you, like post-colonialism or gender studies or you know, doctrinal legal analysis, whatever. And you're doing it in response to events right now. And so I tend, Alice, to think the original contribution, if anyone is a serious scholar, that's going to be a natural result of the work they're doing. I never have understood it to mean I have to come up with a different answer to the question. A lot of my students writing papers feel that that's what that charge is. I think that can end up leading people to be intellectually dishonest. And that is far worse than being a little less original than you might otherwise have been. So that's my concluding statements.
Thank you.
Thank you.
Andrew?
Sorry, yes, just to build on what Diane says, I agree absolutely with what she said. And again, conflating the last two questions, I have a bit of a horror when students write or people tell me that the majority opinion is this and the minority opinion is that, because it only shows, it depends on how far you've cast your web, your net, I should say. I mean, how many authors did you calculate and how did you get a minority and a majority? That to me makes no sense. And to give you an example from, again, from the War Book, the majority of books on IHL say it's okay to kill a sleeping soldier. That is not a violation of the laws of war. The majority of authors say it. Does that make it right? I mean, I think that's a great opportunity to make your argument. So the originality comes not from finding a third way, because there isn't one. Either you agree that killing a sleeping soldier is okay or you don't. It's a one or the other thing. You can't be original about it. But it's how you express your argumentation that makes the contribution to knowledge. And addressing that with fresh eyes today, as Diane says, doesn't mean choosing what other people have said. It means making your own argument on the topic. But thank you very much for a fascinating hour and a half, Bill.
Great. Well, I can't resist trying to add just a comment on Alice's question as well, because this issue of originality, I think we tend to focus on it at the start of the doctoral research process rather than at the end. You know, I'm thinking back now, I've done an awful lot of doctoral examinations. I've been at the ones of my own students, that number more than 50 now, but I've also been probably at 3 times that number, maybe more than that, of other students, and I'm sure that that's the case with the others as well. And I think as a general rule, we don't probe too much at the end of the process about the originality. It's partly because if the answer is nothing, we're in a very uncomfortable spot then. What are we supposed to do? Tell the student, well, go back and spend another 4 years and come up with something original. So I think we tend to pass over it. We're very demanding about it at the beginning, about the question. We say, do a literature review, show us it's demonstrate all of that. But then there's kind of an assumption that once the research question, the originality of the research question is determined, that the problem is solved. And I think that you do want to be, I think what the position you want to be in at the end of your research, you do want to be able to answer the question if someone says, so what's original about it? You want to be able to say, I found something that no one else saw. I looked at these documents, I read this, and I've done something that no one else has done before. And, you know, I think that's the place you want to be in, if you can, at the end. And maybe not everyone is able to do that comfortably. And we're probably not going to fail you on the PhD at the end if the answer isn't very convincing about that. But the idea that you look for something new, that you found new documents, that you had insights into something that others haven't had, that's what you want to. Then you'll have a great answer to the question, and I think that should be your aspiration, even if maybe only 75% of the people are actually going to be able to do that. You know, it's not a disaster if you don't, but that should be the goal. Listen, we've gone over our time a little bit. I know that everybody has a very busy diary and they have lots of appointments and stuff they have to do these days. Someone calls me up now and says, you know, can we find a convenient time? Are you free in July? And I said, I'm going to check my diary. I say, no, I have nothing on in July. No, can do it any time in July. So, but thank you all for being here. We'll meet again tomorrow morning. And my warmest thanks to Diane and Andrew for joining us. We're so grateful for your generosity, spending your time with us and contributing. So if we can give you can either put the thumbs up with the little, where is it? This thing, or we can do a virtual round of applause for them as well. Thank you so much.
Thank you.
And we'll see you all tomorrow morning. Alice,
Bye.
you have to conclude with anything?
No, I think you've all got the programme for tomorrow. And thank you so much for joining us today, particularly to Diane and Andrew as our guests. I think this is a vindication of the virtual seminar and the joys of bringing people together we wouldn't normally be able to do. So thank you both.
Pleasure.
Thank you.
Thank you so much.
Thank you, professors. Bye.